All right, how was lunch? Fried chicken, anyone? Yes. That's the most popular day here in the cafeteria. But I have to tell you that the cheesy spaghetti is as good as the fried chicken. Sorry, that's my spiel for eating here. Before we get started, I wanted to mention that our office, led by Joanne Garrison, is offering a millage workshop. So if you are involved in the tax millage process, if you need a refresher on that, we have 2 live conferences coming up. The first one is in Assumption Parish on March 19th. The second one is in Ouachita Parish on April 11th. If you're unable to attend those conferences, we also have them recorded. The virtual conference that we just had this past week, it is recorded on our website. If you go to our website, lla.la.gov, you can look right there on the top. It says millages, and the recordings are there. But if you have any issues, just contact our office and we'll help you get there. It's my pleasure to introduce our next instructor for review of current state and federal HR laws and requirements for mandatory state training. Ms. Jenifer Schaye is the general counsel for our office. In her capacity as general counsel to the legislative auditor, Jenifer advises on public law issues and law relating to fiscal matters, ethics issues, and all public laws which impact political subdivisions and the audits of political subdivisions on the local and state level. Jenifer also served as a board member on the Louisiana Survivors Benefit Board as the Louisiana legislative auditor's designee. In addition, Jenifer represents the Louisiana legislative auditor and staff in those matters where they are called to testify and/or to produce records for further inquiry by state and federal courts. She advises the Louisiana Legislative Audit Advisory Council on relevant audit law issues. Because of her governmental background, Jenifer has a broad knowledge of the processes of government and the relationships between the various branches of state and local governments. Please welcome Ms. Jenifer Schaye.
Y'all don't care if you can hear me, right? And y'all don't care if I sit. I have this left leg problem that I've been having, and maybe it's good I'm going to talk about Family Medical Leave Act. Hope I don't need it. And then this morning, my right knee started to hurt, so I asked my little multi-poo happy if he could come and give the talk for me, but he said he wasn't interested. So you're stuck with me. So I want to tell you thank you first. I always feel so grateful to be able to share with people like you because I have so much respect for you. I probably have talked to one of you or all of you or some of you over my career in the auditor's office. And I always come away eventually with a feeling of how lucky am I that I get to talk with people like you and to offer some assistance. And that just makes me want to keep doing what I do and proud of who you are and who our state is. So what I'm going to do today is sort of different than anything I've done. I think Diane looked it up and said I had done this somewhat like this in 2015 when we first began doing CLGE. And I said, "Are you sure?" And she, as Diane would, printed out what I had done, and so I said, "Well, I guess I did." But the world has changed, as you might know, as I know, since 2015. I just saw in the news the other day, yet this week, that maybe you don't realize it, but I think March the 12th was the 4th anniversary of when we were all sent home with COVID. And it hardly seems possible that we've had 4 years of different life in America, and now feels like we're sort of getting back to it. But as all of us who have worked in the marketplace for a long time, and I have, this is not, as the commercial said, this is not your father's Oldsmobile anymore. This is a whole different world that we live in. But what I'm going to try to do today is to walk you through, not to be your lawyer, but to walk you through some of the employment issues you might face. And I'm a firm believer that most people only remember little bit of what's said, and probably the little bit comes at the beginning and comes at the end. So at the beginning, I'm going to tell you, if you don't remember anything I say about employment law or the whole issue of employing, I want you to remember a couple of words. And this one's going to surprise you, I think. Compassion. Anytime you deal with employees, be compassionate. Try to put yourself in that person's place. Not that you're the queen or the king, but that you put yourself in that person's place. The other word I want you to remember, if you would, besides compassion, is that you are a fiduciary. You are a trustee of this government, no matter what your job is. You're obviously pretty important, or they wouldn't have sent you here today. But compassion, fiduciary, and then the other thing is that it is the people's government, and we are about the people's business. So if you don't remember anything else, you'll remember I'm sitting, you'll remember my leg, you'll remember that Happy didn't want to come, but you'll remember mostly that you are called to be a compassionate fiduciary. Now, what we're going to talk about is state law, federal law, and your own rules. Which one comes first? Federal law. Federal law is the top of the tree, if you would. It's the top of the pyramid. Then state law, then your own rules. Now, we can be, in our own ways, more restrictive, but we can never go away from federal laws, state laws, and then the ordinances or resolutions that happen in your town, your village, your district, whatever. So we look at that, and that gives us the framework out of which we run. And you might say, because federal law sometimes looks so confusing. What I'm going to try to do is distill it, because it's confusing to me, and I've been working on this for a while to help you. But what we're trying to do is to put the compassionate fiduciary into the context of law. And one other principle is that we always say the specific overrules the general. The specific overrules the general. So if there's a specific federal law, state law can't overrule it, nor can local. If the federal law is broad, which it usually is, and we get it down to something more manageable on the local level, then we can, as long as we don't go outside of the parameters. That makes sense? Now, I know I've been sitting here all morning, and there haven't been any questions. So I really thought they did a great job this morning. All of the speakers did. But if you have questions for me, because what we're talking about is somewhat different, then you'll just wave your hand. Or if you're out in the ether world of the links, then Judy's listening, and Judy will shout out to me what the questions are. So feel free. You won't make me lose my place. I may lose my place on my own without you. Now, distinguish between public and private. Why am I saying that? Because I like y'all, but the workplace is not a family. The workplace is the workplace. It's where we go and we spend the majority of our time, but it's not a family. A workplace must have rules. You say, hey, I don't have children, but I have a little dog, and I do have an extended family. The family has rules too, right? What time you get up, What time you go to bed? What time are we going to eat dinner? You cannot watch everything on TV that you want to watch or on that iPad, right? But there are different rules that are in the workplace. Why do I say that? Because in today's world, we tend to blur the public and the private. We think of it as one, but I'm here to tell you, it is not. There's differences between what you do in your house and what you will do in the workplace, in the market. Okay? If you don't believe me and you try to act in your workplace just like you act at home, you know what's going to happen? You're going to turn out to be, as one of my favorite lines is, above the crease in the newspaper. Somebody's going to write about you. Now, when I started practicing law, when Abraham Lincoln was practicing, well, that's what we talked about, was the newspaper. Now, if somebody makes a mistake, how long does it take to get out? Because it's on social media, right? So it gets out really quick. I don't know how many of y'all have been watching. I feel so bad for Kate, the princess in England. I don't know why they put out that picture that was somehow touched up, but I mean, how many people have tried to figure out whose hands are there? How many times has that been on the internet since Monday? So what happens with all of this, with public and private, is we try to not have just compassionate rules in the workplace, but there has to be rules. There has to be things that happen in the workplace that we talk about in the workplace that are not the same as we talk about in our home. So what I'm going to try to do now is to make you aware of some of the laws and make you aware of some of the pitfalls and make you aware of your need for professional assistance. I cannot tell you enough. I cannot say it, and you'll hear me say it. If you call me on the phone, you talk to me today, this is an area where you are more likely to need professional assistance because everybody has their lane. You're more likely in employment matters to need professional assistance. Do I have to pay a lawyer $5,000 or $500? It depends. There's no cookie cutter answer. But what you don't want to do is to go into the quagmire of thinking that you can do it all on your own, because it's not possible. What you want to remember on your own, though, is that common sense prevails. If it doesn't feel right, it's usually not right. If you feel like it's being arbitrary, it probably is. If you feel like it's not factual, probably isn't. If you feel like it's biased, then it probably is. So trust your feelings, trust your sense. I just read an article the other day about two women who were working for the Social Security in West Virginia, I think it was. Separately, they figured out that there was a fraud going on that between a judge, an administrative law judge, and a lawyer. They said they both had gut feelings. Nobody would listen. Generally, when you have a gut feeling, you need to express it. If it's you're like me, overly thinking things sometimes, it's still good to express it because someone will help you get it straight. Now let's talk about the first thing that happens to you in the workplace. How many of y'all have been involved in hiring? Whoa, a lot of y'all, huh? How many of y'all have been hired? All right, got it. So this is very relevant to you. In all hiring, you're going to look at qualifications, and you're going to look at whether whether you're being arbitrary. You're going to look at pregnancy, you say? Well, you're going to look at pregnancy in the sense that you can't disqualify a person from a job because they're pregnant or may be pregnant in the future. And you can't disqualify, you see, I have on there race or sex, but I'm going to add some for you. You can't disqualify on the basis of religion. You can't disqualify on the basis of national origin. You can't even disqualify you heard of the Crown Act that Congress just passed, on the basis of how I wear my hair. So all of those are to be looked at when you're looking at hiring or you're being hired, or to be looked at. What does that mean? You just said I can't disqualify. Well, I have to ask myself the question, am I disqualifying this person because they happen to be Asian? Or I just don't like short, chubby women who have red hair. What? You can't. Hiring has to be based on real qualifications for the job. You say, let me think about that. Real qualifications for the job, which means that I can't put in qualifications that really don't apply to the job. The United States Supreme Court in a recent case has said somebody put in a qualification that somebody had to be able to lift 100 pounds. Well, say, what's wrong with that? Well, the person was sitting at a desk all day. Did they really have to lift 100 pounds? Or the person was 55 years old and a white male. Did they have to lift 100 pounds? No. So the qualifications have to fit the job. So what I say to you is, if you're going to be involved in hiring, then what you want to do first is to have a job description. You say, oh, I hate that. You're making me go through some process. Right. You're going to love me at the end because you thought about it, of what that job entailed, and you put the process on paper. Then who knows the process? You know the process as a hirer. Your counsel, if you're in a village or a town, knows the process. And the person who's applying for the job knows the process. So what have we done? You, compassionate fiduciary, what have we done? We've leveled the playing field. And that's what is supposed to happen in hiring. There's not supposed to be disparate treatment or disparate impact. What does that mean? Disparate treatment. I'm going to tell you what the Equal Employment Opportunity Commission thinks disparate treatment is. Disparate treatment is what I said just a moment ago, is that you only hire certain people. You only don't hire certain people. It doesn't have to be intentional. It is that you just don't like ladies with red hair. I just don't like it. I don't even know I don't like it. But look, they look at my statistics. There's no ladies with red hair here. That's disparate treatment that has, in effect, a disparate impact. Now, you say, that's the rule, right? That's the rule. I got to do it, right? Yes. But what's going to happen to you when you don't have disparate treatment and disparate impact is you're going to have a better workplace. The better workplace is the diverse workplace. It's where the Asian and the African American and the Caucasian are all together going for the common good. I can see Judy.
Hey, Jenifer, we have an online question. They want to know, what about age?
I'm sorry?
What about age?
Age is a discrimination. I should have said that. what the EEOC looks at is if you're over 40. I'm happy about that myself. You know, if you're over 40 and you tend to discriminate against people over 40, but it does still depend upon what is the job. Now let's talk about that somewhat. In the next one, we're going to talk about enforcement priorities. Look at those. So, first, ADA. What is ADA? Americans with Disability Act. Believe it or not, 30 years ago, people couldn't have said that. But now you know it, don't you? Now you see blue curves. Now you talk about it. So Americans with Disabilities Act has made us aware. What's an ADA impairment? It is when you have a life-limiting activity. Now, do I have to hire somebody with a life-limiting activity? Depends on what your job is. Can you hire a blind truck driver? Not so good, right? Could we hire a blind CPA in the auditor's office? Maybe, depending on what accommodations we could have. All accommodations have to be reasonable, not an undue hardship on the person. We once had in the auditor's office a young person who had MS. That's a horrible illness, right? It's horrible. It depends upon what happens, but it's not good. The person wanted a $20,000, not 20, I'm going to be right, $5,000 chair to sit in, $5,000. We had to accommodate the person sitting in a chair. We wanted to accommodate, but we found a chair that cost $1,500. Did we accommodate? Yes, we did. Judy?
One more question, Jennifer. What about a criminal record?
A criminal record is not something that there is a whole lot of talk about. Check the box. If you can, or don't have to check the box, if you can have a situation where that criminal record, that particular thing is not going to impede the work, then there is an accommodation that can be offered. It's not mandated, but there's an accommodation. East Baton Rouge Parish now has an ordinance that you can't immediately disqualify. Go down to the other. I want to say something about another thing about ADA. It's not ordinarily a temporary condition, but it can be temporary. ADA. Don't put this on the internet. I do not have cancer. I don't want cancer. I'm not brave enough. But if I had cancer and I had to take an immunotherapy drug or chemo or some infusion, and for that time I needed an accommodation as to my work hours, as to how I sit in my work and so forth, then that accommodation should be made, and that's reasonable to do that. But it's not that I go home today and I don't feel well. That's not. ADA is dealing with life-limiting activities, okay? I'm crippled. I'm deaf. I can't see. But it's also got to go with what is my particular job. Does that make sense to y'all? Okay, so LGBT is lesbian, gay, bisexual, transgender. I can't discriminate there. And so that has to be, and I don't think I have to ordinarily make an accommodation, but those are enforcement priorities for me. And pregnancy is one that we have just came into play last June, the Pregnancy Fairness Act, which most usually deals with accommodations during that period. There was a case, the UPS case, that brought it all to light that people were not making accommodations for pregnancy, and then Congress passed the Pregnancy Fairness Act, and we actually have a version of that in Louisiana. But always, 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 why did I talk about your job description? It's not an undue burden on the office, on the workplace. So it's a reasonable accommodation. That's what you're looking for. The special chair, but not the most expensive chair. The new monitor, because I had eye surgery, but maybe not the most expensive monitor. We've had situations where we've had people that are ADHD and need special work accommodations to learn to read what they have to read and to comprehend it and then to audit. Do we offer those special accommodations? We do, and you should. Any questions on, yes? Now ask your question real loud so I can hear it and everybody else can hear it. No, no. Can I repeat the question? Do the same rules for accommodation apply to independent contractors? The answer is no. But I don't think you can be arbitrary either. Does that make sense? I think you might have some problems if you were being arbitrary. But I am going to talk about contractors, independent contractors, and employees in a minute. But we're here, okay, we're now at equal work, equal pay. Why do we say that? Equal work, equal pay. Because if I'm doing the same job as you're doing, it doesn't matter if I'm male or female, does it? It shouldn't. We don't have an Equal Rights Amendment in the Constitution of the United States, but we have laws that say equal work equals equal pay. So what I recommend, so that you don't have problems with equal work and equal pay, is that you have practices where you treat everybody the same, that you have written manuals, and that you have supervisory training. Now, people will look at this slide today and say, this won't be hard, right? Because I can go to AI and get the manual. It'll be written, right? Artificial intelligence. Can I do that? Should I do that? I recommend you might want to start with that, but you don't want to end with that. You want to look at, what do I need in my employment manuals in HR? And you might want to start with AI. And then what do? You test it in the marketplace. The way the speakers this morning were talking about, test your budget. Test what's happening in cybersecurity. So you're going to have to ultimately come up with written manuals. I think the most important phrase on that slide is supervisory training. You cannot have a good, solid, happy workplace unless you have supervisors who are compassionate, who understand their responsibility. So that doesn't just happen. That happens because you continuously are training yourself. You're continuously trying to see, what's the best way I can talk to this lady? What's the best way I can listen to this person rather than just always talk? I have to practice that. I have to hear what my peers say about how to be a supervisor. So when you look at equal work, equal pay, you're going to look at, what are my patterns? What are my practices? Am I being arbitrary? Am I requiring more than I should require for qualifications for this job? Am I really trying to be the best supervisor? What did you hear me? Trying to be. Practice makes perfect. Judy?
Just want to verify, to be clear, AD8 is not applicable to contractors, correct?
Not in the same way as it is to employees. Not in the same way. But it's not cookie cutter. You may say in your workplace, we're going to contract with people who have certain disabilities. Contracting is different. That's a service. But you don't want to be in a discriminatory situation. Or remember, you're going to be above the crease, and you're going to be on everybody's telephone, everybody's text message. It's just not right. Supervisory training, to go back to that, I want to make sure that you understand that's something you have to continuously do. How many of y'all like LSU baseball? If you don't, you're out of this class. Y'all all like it, right? Well, my favorite player on the LSU baseball team is a guy who plays third base, Tommy White. He last year did great, even when his shoulder was not good and they had to, I can't imagine this, they had to pop it back in place 20 times during the season. But this year, my guy Tommy, he hadn't been doing as well at the plate. So I said to one of my friends who knows everything about baseball, I said to him, what's with Tommy? Did he read his press? Is that what's wrong with him? Because everybody said he's going to be an All-American. Everybody said he's going to be a multimillionaire next summer. What happened? He said, you don't read enough, Jenifer. That was a compliment, I guess. I don't think it was. What happened? Tommy didn't get to practice all summer, all last summer. He didn't get to practice in the fall because they went and operated on that bad shoulder. What does it take to be a good hitter in baseball? In case you don't know, hitting a ball with a bat is one of the hardest things in all of sports. Tommy didn't get to practice for 8 or 9 months. So they say it's going to take him half the season to get into form. Supervisory training is like that. You continuously do it so you can think about all the alternatives. Think about Tommy. Now, if we look at this is harassment. We can have racial harassment. We can have sexual harassment. We can have hostile work environment. You see how they're all going to hostile work environment? Because we tend to think that it's only racial, it's only sexual, and look at them in separate categories. What I want to say to you is, if you have an environment in work that is not tolerable, and it's not just not tolerable for the person who's made fun of because of their sexual orientation, or the person who's made fun of because of their hairstyle or their skin color. If you have that kind of environment, then you have a hostile work environment, and you are subject to liability from those victims, not just the person. You say, well, let's go back. Let's see. Remember, it's a public place, not your house. It's a public place. So what makes that become a hostile work environment? Tick it off. It can be subtle or it can be crass. But what makes it? Language, words that you say. If you say the N-word, that becomes a hostile work environment. The courts have said, say the N-word once. That's all you have to do, and you have a hostile work environment. It can be your demeanor. I'm not walking next to you. I'm not. I hate women. Or I hate men. I'm not going to be. That's my demeanor. Or maybe goes the other way. I have incredible sense of touch. Too much. You're invading my space. That can create a hostile work environment. It's my office, right? I can put up any pictures I want in my office, right? Wrong. Wrong. Even if I keep my door closed, I cannot do that because that may be offensive to some people. Say, how am I going to know? Ask, test it. Or it could be like the Supreme Court justice said about pornography. You'll know it when you see it. You'll know it. What about music? Some music can create a hostile work environment. What about jokes? What about jokes that have overtones? That can create a hostile work environment. You're always looking at all of this stuff is interrelated, private, public. And your house, if you want to have a picture of a naked person in your bathroom or wherever, can you do that? It's your house, of course. If you want to do that, do that. I renovated a house about 7 years ago. I inherited from my parents. And the lady who was helping me, she calls me frantically one day. I have found the best picture for your guest bathroom. Said, okay, if you've ever renovated a house, you really want it to be over. It gets to be a long process. So I was ready to say yes almost to anything. Then she told me what she had found. A nude picture from my guest bathroom. I said, no. She said, what is wrong with you? It is just the right colors. My house. I wasn't worried about hostile work environment. I just don't want a nude picture in my bathroom, right? That's my house. I can make that call. When you're in the workplace, you make the call thinking about all the people who are around you who also have rights. You have rights, free speech. They have rights, 14th Amendment, to be treated in an equal and equitable manner. That makes sense to you. So we work through those, and then we get kind of a summary. We look at overtones, suggestions, hostile work, intentional acts. Most people, when we talk about these things, would say, what's the worst thing? Intentional acts. Not really. See what I have underlined? Hostile work environment. One that makes me feel uncomfortable coming in to this situation. Now, supervisory liability is something that most people don't want to think about. And you have prima facie up there, and prima facie means on its face. So if an employee comes in and says, I think I've been discriminated against. I think that Jenifer discriminated against me. And here and here and here is what happened. Unless it's totally ridiculous, they have made a prima facie case on its face of discrimination. And the burden of proving it's not discrimination, that's why we got the seesaw up there, falls on the employer, not on the person to prove it, on the employer to say why that isn't. Now, I say, how do you remember that? Well, you don't want to act like the little monkey statue, those three. See no evil, speak no evil, hear no evil. When you do that, you put your head in the sand and you get ready to get sued, or to have the EEOC calling you up saying, fill out this 30-page form. So your prima facie case, how do I guard against that? I say it is ongoing vigilance. It is, and you all in financial issues understand this, it is documentation. It is not ignoring. It is no excuse to say, don't worry about it. That's just Jenifer. That's the way she acts. No. If you think there is an issue, you address that issue. You communicate on that issue. But remember how you're communicating. Remember what I said when I started at 1240. At 1240, I said, you are compassionate, you are a fiduciary. You're going to get both sides. I've been involved in more HR investigations than I want to tell you about. But I'll tell you one thing about all of them. There's always more than one side to every story. There's always people who think this, who think that. And you want to make sure that you're listening in the whole way. But you have to know who has the burden. You do as the employer. Now, I come back to this because language is critical. How you talk is extremely critical because it's individual rights, but it's also the rights of the group. Do you have a question, Marshall? Okay. All right. So we go back to the workplace is different, but here's what we're looking at. We can't use slang in the workplace. Like, what's slang? Well, I don't know. I hate to admit it. I try to keep up, but I don't know all the slang. I don't. I'd say slang for me is he's a freak. That's slang. But my new executive assistant tells me T is a slang. I don't know. Cursing. I mean, say it right here. You can't. There is no excuse for using any curse words, any words that are curse words. Just can't do it in the workplace. There's no way that you should be involved or allow yourself, or allow your employees to be involved in any suggestive language. She's hot. He's hot. That's cool. We can say that at walk-ons tonight. But it shouldn't be something that we're going to talk about in the workplace. In my home, with my family, in my privacy, that's okay. But not in the workplace. It's the Supreme Court of the United States said once to talk about individual rights and the rights of the group. What can't you do in a crowded room or crowded theater? Yell fire. Good. Can't yell fire. Not right. Say, I got a right to say it. Yeah, at your house. Not in the midst when I have my rights. Okay? Now, have you ever heard of this case, Oberfell? Oberfell is the case. Two elderly women had lived together for years. One dies. State of Ohio says one can't inherit from the other. And it all rested on whether they had a civil union. Obergefell from the United States Supreme Court said civil unions must be recognized between same-sex couples. Now, you can have, and I can have, my personal religious beliefs about that. But that is the law of the United States. And that is a seminal moment in our history today, where that has changed the tone of how we publicly relate to sexual preference, how our laws relate to it, how our jobs relate to it, how our workplaces relate to it. Because of Obergefell, we have a different sense. We're going to talk about it with the Family Medical Leave Act, because same-sex couples adopt. Health coverage, because we have same-sex spouses. And beneficiaries, spouses, and children. So Obergefell began to give us the change, and then it has ripple effect throughout the laws. I'm going to go back now to another change, and that is social media. But it's hardly a change anymore. It is where we are with social media. But I think it's appropriate to mention in any context of HR laws, because public versus private, friends versus business associates, you should really examine in your workplace manuals what you say about how employees can participate on Facebook. Concerted speech is allowed. I'm allowed on Facebook to be critical of my employer, but I'm not allowed to defame or slander. Now, I say, as a non-employment lawyer, but your friend, well, maybe not your friend, but your lawyer, I'll be your lawyer for a moment, really consider what you put on Facebook and who you friend on Facebook. I value my relationships with people in the auditor's office. I've been there 24 and a half years now. I love working there. I have no Facebook friends who work at the auditor's office. That is by intention, because public versus private, I don't think it's appropriate. Text, instant messaging, videos, pictures, all of that you look at as you think about the workplace and who shares what. You say, you're not telling me I can't show the picture of the cute little babies. No, I'm not telling you that. But I might be telling you that if you go to Mardi Gras and you see what we see at Mardi Gras, you might not want to share that with your work friends, right? That's what I'm telling you. Is it going to happen every time that it's going to be offensive? But not every time. But I would say, here are the considerations. What do I put on social media? Who are my friends on social media? And what will I be judged by on social media? Because it's absolutely legal. You hearing me? It's absolutely legal for an employer to look at what you have on social media before they hire you. You can't say, hey, why did he look at that? I'm really not like that. Then you shouldn't have put it on social media. Any questions on that? Okay. All right, we're going to go just quickly. Accommodations have to be reasonable. No cookie cutter answers. And no answers that are just way out of the ballpark. Remember the $5,000 chair, the $1,500 chair. I say, I have to have handicap parking, but that's different than saying I can never travel if travel's part of my job. We had an interesting question the other day um, from one of you. We, as you know, Diane referenced it. We have FAQs and we have database of, I don't know, more than 1,000 questions out there that you can search, totally searchable. And we had one the other day that an employee of a local government has to travel to a meeting that they think this person has to go to, and the person has a service dog, a legitimate service dog. Not me saying Happy's a service dog. He's not. He's a juvenile delinquent dog, but he's not a service dog. But this person had a service dog. What was the question? Could they pay for the service dog to travel with the person? What do you think we answered? Yes. I said, you could go ask the Attorney General. I'm not the Attorney General. But if you all have determined that that really is a service dog for that person, and you really want that person to go to that training, that person can't do the training in any other manner, I think you can pay for that service dog. I don't know what happened. I don't know. No cookie cutter answer. Who makes determinations about reasonable accommodations is the Equal Employment Opportunity Commission. They have a lot of stuff, and as you look at our information, you'll see we have links to them. That's where the 14th Amendment and free speech kind of get weighed. But what do you make accommodations for? What kinds of illnesses? Diabetes, cancer, intellectual disabilities, epilepsy, pregnancy. But you still have to do the job, even as you make the accommodation. So you ask, this is how, I'm going to go back, I'm sorry. How to accommodate? These are the questions I would ask if I would be you on that. Did they ask for an accommodation? What's a job? What does best qualified mean? And don't disguise best qualified. Sometimes it's hard on the first one. Did they ask for an accommodation? Sometimes people are embarrassed to ask for an accommodation. I don't want to tell you. I had to ask them to help me. I can't walk up those steps today without thinking I'll fall on my head, make it even harder than it is or whatever. So sometimes you have to anticipate the accommodation. But on the other hand, you don't have to go overboard. So did they ask for an accommodation? If they did, you need to give an answer. You can't just say, put it in file 13. I'll answer you in 6 months. What's the job that I want them to do that they need the accommodation for? So those are things I would say you look at. There can be no out-of-hand disqualification of a person. No unreasonable accommodations. So as you can't out-of-hand disqualify, neither can the person ask for an unreasonable accommodation. Okay? This pregnancy discrimination, as I told you, came out of a UPS case. There's a show going on CNN right now. It said, what were they thinking? And I don't know if any of y'all have seen it. It's I think it's Jake Tapper doing it, but it's on Sundays, and he's looking at scandals in America, and saying how could certain things have happened? Really smart public officials just making horrible decisions. Well, that's like the UPS case. They had a young woman who was a UPS driver, and all she asked for It's documented in the case. All she asked for was during that time of pregnancy, could she have another job, not have to lift the box? That's all she asked for. They had other people working in the office. You probably know UPS, they can't work without people working in the office, right? They don't just have people on that truck. You know what they told her? No, 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 you quit. You have to leave. Well, thank God for us, she didn't leave. She filed suit. And that's where, out of that suit, came the Pregnancy Fairness Act. She had a right, they said, to have a different job for that period. Now, the pregnancy, this gets back to the disparate treatment that I was talking about before. Remember, all of this kind of works together. If I were not pregnant, would you accommodate me? In that case, they had accommodated male and females who were not pregnant with different jobs, who had back trouble, who had leg trouble. They had done that. If I'm not pregnant, would you reassign me? They had done that. If is a lack of accommodation a pretext for discrimination? Now that's hard. That's hard. You say, how do you know what I'm thinking? I don't. But I look at what's happening. Judy?
If you make an assumption that an accommodation is needed without an employee asking, is that considered discrimination?
I don't think so, because I think it's going over and above. Now, the employee can tell you no, they don't want it. And you're not going, in making that accommodation, and maybe that's the back of that question, I'm not going to have the right to expose that person's personal identifiable health information. I'm not going to do that. But I just want to be the compassionate fiduciary. I think that's appropriate and sometimes necessary, depending upon the person's situation, the person's character, not character bad, but just ability to communicate. So what are you thinking in this case? That was Miss Young versus UPS. We're looking at disparate treatment, disparate impact. Now, there's something called the 80% rule. So if I hired, what they're saying is, if you had 100 people apply for a job, 100 white people, and you hired 50, then your hiring of the black people or Asian people should be more than 50% of that 50% total that you hired. 80% of that 50%. That makes sense. Don't worry about it, because what they have moved to is look at the totality of circumstances. The totality of circumstances. And we have struggled with that, and I don't think Mr. Wagesbeck would mind me saying this, because he's into transparency and accountability. We have struggled with that in our own office because we want a diverse workplace. Well, we have tried to hire CPAs who are not Caucasian, and it's very hard. One is, and Diane is on a national board, and she'll tell you a lot of people don't want to be CPAs today. So you don't have that many to choose from. And then when you get to minority populations of African American or Asian or Indian or Hispanic, it's even harder. But I feel confident that we would never have a problem with the EEOC on that, because all our advertisements on social media indicate we want to hire and we recruit in minority settings. But if people just don't exist, they don't exist. But That's why we look at the totality of circumstances. I haven't talked about religious discrimination. I know I skipped the other one. I intentionally go to this one because this is a case that is really the landmark case right now for religious discrimination. Simply it is. A football coach wanted to pray on the field after the game, a silent prayer with his team. He didn't make them come to the huddle or to a huddle to pray. He was going to pray, and young men came and prayed with him. School district said, "You're fired." It wasn't Donald Trump. School district said, "You're fired." I meant Donald Trump because remember The Apprentice? You're fired. That case, that show on TV. Supreme Court said wrong. He had a First Amendment right for free speech, or that is not violating the Establishment Clause of the Constitution, which says you can't establish one religion like England had. So that case is really looked at religious issues a little, made us look at them. Something not quite as dramatic as Obergil, but something like that. You still can't have overt religious activities in a public place, overt, especially in a government setting. You can't have that. But somebody's in the middle of a football field, silent prayer is different than if they were on the PA, like it was when I was in Catholic school and the principal was leading the prayer. Couldn't do that in a public school today or any time. All right, now I'm getting ready to go into something entirely different, exempt and non-exempt employees. So I've been talking, I've got 25 more minutes. You want about 3 minutes just to stretch? No? Keep going? Well, if y'all want to, somebody wants to get up, not a problem. Let's talk about now, we're in the marketplace. Is that okay, Diane? They'll still get the credit. I hadn't messed up. Not yet. Exempt and non-exempt employees. I'm going to go through some of this rather rapidly, but I know it's things that come up. Who's an exempt employee? That's an employee who's entitled to overtime. Not entitled, I always get it wrong. Not entitled to overtime. That's an executive supervisory employee. But again, we're going to look at the definition of the totality of circumstances to determine. We're going to look at what makes exempt employees. So let's talk about that first, and then we're going to talk about some overtime rules, some exemptions, contractor versus employee, and then I'm going to end with FMLA. Can I do all that in 25 minutes? Let's try. I'm going to see if I can. When you have non-exempt employees, what we're talking about is people who are hourly wage people who then are going to be paid overtime when they go more than their ordinary 40 hours. Now, step back. If the employer, the government, wants to pay me more, I'm not an hourly employee. They figure out my hourly rate so that they can put it in the state budget. But ordinarily, a professional is not an hourly employee. But if the auditor wants to give me comp time or wants to pay me for my overtime, can he do that? Can you do that in your local government? Yes, if you have a policy and if that policy is prospective. Okay? So you can do it. When must you do it? You must do it for your non-exempt employees who are ordinarily your hourly rate people, the people who are running the garbage trucks, the people who are cutting the grass, the people who are painting the rooms. Are they less important? No. They just have a different job than me. But they deserve, by the law, the Fair Labor Standards Act, to be paid when they're overtime. Okay? Ordinarily, it's not going to apply to executives, supervisors, or professionals. Good record keeping is critical in all of this. The responsibility is on all of you. How many of y'all do payroll? Oh, then you know what I'm talking about, huh? You got to figure it out. You look at the minimum wage, you look at the overtime. Minimum wage, you might have chosen to get more than the $7.25 an hour. So, depends if you have passed it by ordinance. So, you want to make sure that you do it for everybody the same. Remember, the compassionate fiduciary is not arbitrary, right? Not arbitrary. Everybody gets it. Now, if we have exempt versus non-exempt, you can look at it. Those definitions are provided. I've talked about them. But what we're talking about is the Fair Labor Standards Act looks at one group, the IRS looks at it, and they're all trying to figure out what is your pay. And you know why the IRS wants to figure out what is the proper pay? Taxes. Why does the Fair Labor Standards Act, why do they want to figure out the pay? Because their mission is fairness in employment. Two different missions, but it all kind of comes together, right? So Department of Labor is going to be looking at the treatment of wages and employment. The IRS is going to be looking at, did you pay your taxes? All right, I kind of mixed into this, kind of all gets kind of worked together, is am I an employee or am I an independent contractor? And here's some things that you look at. Does a worker control their income? Second, does a worker bring their tools and equipment? Third, is this a temporary job or is it a job that's integrated into the main work of this company, of this group? Who has control of this person? Is it essential to what you do? Does the person exercise independent judgment? Say, all those sound like what you do in a private workforce. They are. But they also happen in government. And why do people want to keep people as independent contractors? You know why? They don't have to pay that part of Social Security, right? They don't have to pay that. I'll give you a 1099 and then you bring it to your tax person at the end of the year. Well, what IRS is saying, what the Fair Labor people are saying, is got to look at the whole picture. Am I really a contractor or am I an employee? And if I'm an employee, then I have different tax consequences. Otherwise, I don't. So I'm going to look at some behavioral issues. I'm going to look at financial issues. And I'm always going to look at the relationships. If I provide insurance for this person, if I give this person benefits, if this person is key to my business, probably an employee, huh? A lot of times, government doesn't want to do that because they don't want to provide insurance. They want to provide benefits. So what we're saying is make those determinations up front. Ask the hard question. Judy?
Are the exempt, non-exempt laws applicable to nonprofit agencies as well?
They are to some degree, yes. For employer-employee, they are definitely to it. Some applied somewhat differently, but yes, the answer is yes. Not the same as government, but they still apply. Here's the common rules that the IRS has. They're worried about taxes. Now, that's for the employee-employer relationship. They are worried about outcome. The totality of the circumstances is what they look at. I've come back to employer-employee. I'm looking at that, not exempt, non-exempt. Now, here's a group that makes it a little bit different, and that's the policemen and the firemen, because they have different labor hours to compute. And on these, you absolutely have got to have a professional helping you to calculate that and to make sure you're applying it properly. Because what you don't want to get into as government is that you have to pay back taxes, because back taxes cause you to have penalties and interest. The white collar exemptions apply to when you're going to give overtime or not. But you can give overtime. You can. In the auditor's office, if I work 80 hours a week, I do not. But if I did, and my ordinary week is 40, I can get 40 hours of comp time, provided that I can document it properly. Salary basis test, it's still there, but I say to you, it's more the totality of circumstances. Highly compensated people are generally in the private workplace not going to be considered non-exempt employees. I'm skipping over some of this so I have enough time to talk about. Look at all these charts. I want to talk about this just for a minute. The on-call pay. How many of y'all have on-call employees? Okay. So that can be a problem, right? Are they really on call? Here's how we do it in our office, and we've researched it once or twice, 3 times. If they're constrained from engaging in personal endeavors, they're on call. If they're constrained. Now, if you don't care that they go fishing 100 miles away and can't get back to fix that computer, is that IT guy on call? I don't think so. If you say you're the IT guy, but you can go to the mall today because you can be in the mall with your telephone in a private space to answer Jenifer's stupid question, then the IT guy gets paid for being on the help desk. Does that make sense? So on call, you got to look at it, but there's a lot of literature out there, but it boils down to if you're constrained from engaging in personal endeavors. Okay? All right. Now, can I, if I've given comp time for exempt employees, can I just say, okay, how many hours of comp time do you have, Jenifer? 300. Okay, my policy's changing. You don't have 300 anymore. Can I do that? The law says no. Can I change it prospectively? Yes. Can I say you can't carry comp time over from one year to the other if I had it in my policy? Answer, yes. I just can't go and rob me with a new policy. So you need to look at that and determine what you want to do. Okay. Still with me? You're awake? They gave me the horrible time. So you better give me good evaluations because I got the after lunch time. And she's talking about fried chicken and carbohydrates, Anyway, so here we go. Family Medical Leave Act. Do you want to shoot yourself sometime with that? Because that can be kind of confusing, right? Here, let me tell you if I can boil it down for you. And I got about 15 minutes. Tell you all I know. But I might not know this much, but I think I do. What's it generally apply to? Generally applies to birth, adoption, taking on foster children, serious illness, or care for United States Army, Navy, Marine, whatever, service members. That's what it applies to. Who gets it? Someone who's worked at the public agency. It applies to all public agencies, no matter the size. Who gets it? A person who's worked there at least 1 year and has worked at least 1,250 hours. 1 year, worked at least 1,250 hours. What do you get? 12 weeks right now, unpaid leave. If you work for the state, there's a different thing, and you get some paid leave. But most of you work for local government, right? So it's 12 weeks unpaid leave in 1 calendar year. Okay. We got sick leave. Can they take their sick leave as part of that 12 weeks? Yes, they can. So the qualified person and a qualified employer can do that. They can make sure that they work for a covered employer. You are all covered employers for 12 months, for the previous 12 months. So you can't say, I worked there 3 years ago. Do I qualify? No. It has to be the previous 12 months before you ask for the family medical leave. That makes sense? The previous 12 months. Now let's talk about what is a serious health condition. It isn't that I broke my fingernail. I'm being ridiculous, although that's pretty important to me. It is that I have a serious illness that might require hospice care, that might require continuing care, or might be part of my pregnancy. It's a serious illness. That's in addition to what I told you before about birth, adoption, foster care. Okay? Also, if you had a service member, it would be a service member leaving, or a service, and you had to care for the children, or a service member coming back who had some serious disability. Who gets it? Who do you take it for? Obviously, maybe not obviously. I can take it for myself. I can take it for my spouse. I can take it for my child. I can take it for my parent. Myself, my child, my spouse, my parent, and the service member, they do a thing on next of kin. Does that make sense to you? So that's who you're taking it for. Are you entitled to pay? Currently not. That bill has been in Congress for a while. It still hasn't passed. You can use your paid leave, your previously accrued paid leave. This is not the same as crises leave. Family medical leave, every person who is a covered employee who works for a covered employer is entitled to family medical leave. Okay? So, can the leave be a block of 12 weeks in that year? Answer, yes. Can the leave be split in that year? I'll take 6 weeks now. I have an ill parent. I'll take 6 weeks. I'm going to get you. And then my sister's going to take 6. And then I'll take my other 6. Yes. Covered employer is any government employer, no matter the size. Yes. Okay. Depends on your policy. Depends on your policy. You can require in your policy that 12 weeks be part of the 365. But you got to give them the 12 weeks. Yes, that's a good question. Thank you. Usually not. Depends, though. It's not a cookie cutter. Some people can have, unfortunately, have knee surgery and they have some kind of horrible complication like a bone infection or sepsis or something like that. That would have to be qualified as a serious condition. Yes, Lizzie. 5 minutes? 5 minutes. Oh, I thought she was asking me a question. Tell me I got 5 minutes. Yes. You're what? I'm sorry, I can't hear you. Public defenders? I think you're public employees, but that's my opinion. I don't know what the Indigent Defender Board would say. I think you're not on contract, are you? But I don't know what the public defender law says about whether you're considered public employees. If you don't mind, would you send me that question and let me do some research on it? I'd be happy to do that. I'd be happy to do that. I'm going to stop. Well, I'm going to keep on. I think I've given you what I need to give you on FMLA.
Well, Jenifer, I have one FEMLA question for you.
Can I go 5 more minutes, Diane? But past my time. Okay, thank you.
Is FEMLA applicable if you have a significant other that's long-term, but you're not married, 20 plus years, et cetera?
Say it again.
Is the FMLA laws applicable if you're not married to your significant long-term other? You know, like a live-in spouse, but not married. I mean, live-in partner, but not married.
I don't think so. But if that person wants to send me that question, we can research it. I just want to stop on FMLA, even though I have a few more things. Y'all wouldn't believe this. I thought I wasn't going to have it. I thought I was going to have all this extra time. And Diane and them were going to get mad at me because they said you had to have so much to make y'all get credit. I just want to go through the ethics, the training real quick. We have a white paper on this on our website, on the auditor's website. ethics training, you all have to have it. Public employees, elected officials have to have 1 hour of ethics every year in a calendar year. Got to have it. You got to have it the way the ethics board says you have to have it, which is either face-to-face ethics training or their prescribed ethics training on their web, or training that a trained ethics person gives you, the ethics liaison person for your agency. You cannot skip ethics training. The auditors have it in their compliance questionnaire, their state agreed upon procedures. You've got to do it, okay? So that's one mandatory training. Another mandatory training is sexual harassment training. The sexual harassment training, you have to have 1 hour annually. Again, supervisors have to have an additional hour. And what kind of sexual harassment training you have to have is whatever course is approved by your agency head. Yes, ma'am. The consequences? Well, if you don't do it, the ethics board can fine you for the ethics training. The mandatory training, you're going to have an audit on sexual harassment. You're going to have an audit finding on that. Local government, on the sexual harassment training, you keep that record. The statute says you keep that record there so far. Our agency, we have to send it in to the legislature. Yes, ma'am. Every public official and public employee that comes under the definition, in this case, of public servant. Yes. Then the final training is it's a new one, the cybersecurity training. The cybersecurity training is for all public employees that you have it once at least, unless your agency head says you have to have it again, and that you have it within 30 days of your first employment. That cybersecurity training, again, is chosen by your agency head. Also, anybody who contracts with your agency and has access to your agency's security, all your internet stuff, your confidential stuff, has to have, your stuff is a legal term, you understand, has to also have the ethics training for the term of the contract. It should be a part of the prescribed part of the contract. And if that contract is renewed and they still have access to that confidential information, it has to be renewed. But again, have the ethics training. That has to be turned in to the Department of Civil Service by March 31st of every year. Okay? I thought I was going to have time for questions, and I have time to sit here for questions or to go out there for questions. But I wanted to say thank you. Thank you for your attention. Thank you for allowing me to do this.